if a doctor misdiagnoses is some type of ailment, is that something that can potentially be medical negligence?
Oh, yes, certainly. I mean, if there's a misdiagnosis and that miss causes delay in treatment, cancer is probably the number one area that we would look in that particular type of claim. Certainly that can be an action. Very difficult, but if that delay has caused enough of a, if that oversight has caused enough of delay in your treatment, then certainly there could be a malpractice action.
And one of the interesting aspects of medical negligence, I think, is something that we all have many times in slip and falls that happen at hospitals, where a client is a patient receiving treatment and is under the care of the physician or the nurse, and then we have to make a determination: is this a negligence action under a slip and fall, or is it a medical malpractice action?
Right.
And there's various variables that we use to determine that.
Right, and it's actually a strict determination. If they are under the care of a doctor, a physician, a healthcare provider, by definition, then it's going to be malpractice, even if it's a slip and fall type of negligent action.
And I would like to bring up that, sometimes it's always good to seek out competent legal representation, because just because you were injured by a doctor, as a client, you may go to see a medical malpractice doctor, and he may decide that, hey, yes, there was something wrong here, but the costs don't justify the actual lawsuit. However, it's important, to go get second opinions, to talk to attorneys, such as attorneys at the Pendos Law Firm, because Florida law will actually allow you to relate medical malpractice to an initial car accident. So for example, if you were involved in a car accident, you were transported to a hospital, and medical malpractice occurs, a doctor makes a mistake, in those circumstances, you are actually able to relate the medical malpractice back to the initial car accident. And that's why it's always important to have a team of lawyers, like we have here at the Pendos Law Firm, look at your case, because every case is going to be individualized, because there may be a determination made that, hey, the medical malpractice is not the angle that we want to go for here. We may want to relate all of this to the initial car accident, because the car accident is simpler to prove, it doesn't cost as much money as a malpractice suit, and we're able to recover for those damages that occurred not only in the accident but later on in the hospital. So it's always important to not only let your attorney know, hey, this is what went wrong in the hospital, but to give them all the facts surrounding, hey, how did you get to the hospital? Was there an accident beforehand that led you to the hospital? Because as attorneys, we can look at these sets of facts and help you chart a course that's going to be the most cost efficient and the most beneficial for you as a client.
Agreed, but the sensitivity is still there for the time factor, in that the malpractice action is going to have a 2-year statute of limitation, whereas the car crash would normally and generally have a 4-year.